Everyone, this is the part of the lesson. Okay, there are actually we call this 5 categories of different kinds of contracts based upon effects. First one's rescissible. Okay, now rescissible contracts are validly agreed upon and may be rescinded. That means may. Okay, that there's a possibility it may be rescinded because rescission is a right usually granted by law, and once there is no law allowing rescission, it is generally not given as a right or as a remedy. Okay. Now, for added illustration, Article 1381 provides the enumeration, although this is not the exclusive enumeration of rescissible contracts. There are others contracts which are rescissible because the law allows them to be rescissible. Okay, that's Article 1381. Now, there is a case here, meaning Olesenko versus Oseta and Hernandez. Okay, we will look for that case right now after the lecture on rescissible contracts. That's Olenko versus Oseta and Hernandez. Okay, regarding the requisites of rescission. Okay, now the controlling concept of rescission is that there always ought to be damage, or a violation of the terms. Okay, which would give rise for the right to have the contract rescinded. Okay. Now, Article 1382, payments made in the state of insolvency for obligation to whose fulfillment the debtor could not be compelled at the time they were effected are also rescissible. Remember, the contract has to be created during the time that insolvency is effective. Okay? Because insolvency, the way I remember my civil law procedure, has a 2-year limit. Okay, once you're declared insolvent, there's 2 years that you cannot enter into any contract whatsoever. Now, Article 1383. The action for rescission is subsidiary. Cannot be instituted except when the party suffering damage has no other legal means to obtain reparation for the same. In short, you have to exhaust all other remedies before you resort to rescission, even if it is granted by law. Okay? By the mere fact that the parties only agreed upon rescission and there is no actual positive law allowing rescission, okay, you cannot demand rescission as a matter of right. Okay? Now, rescission shall be only to the extent necessary to cover the damage caused. Okay? So it cannot go beyond that. Now, can damages also include all other acts in consequence? No, because in rescission, okay, whether the act was done in fraud or not is not really an issue. Okay, you're just enforcing a remedy granted to you by law. So how was it in fact, how was the damage sustained, okay, and by what manner was it incurred, okay, is not really a question. The question is there damage or not? And damage is a necessary element of rescission. Okay, this is Article 1385. Okay. Okay? Remember, the effect of rescission is that you're supposed to return everything, okay, that you have gained by virtue of the contract. If you can't return what you actually got, then rescission would fail, okay, as a remedy. Even if the other party is willing to return what he has managed to get through rescission, the rescission will fail if you cannot perform your end. Okay? Now, damages is not supposed to be what do you call this? Supposed to substitute, okay, the object or whatever benefit you have gained from the contract prior to it being rescinded. Okay, so in continuation, now rescission cannot take place on the second paragraph because the object of the things, okay, or I mean the object or thing, okay, which is the object of the contract, already belongs to the ownership of a third person, and legally he cannot, okay, return them absent any proof that the contract was made, okay, in fraud of creditors. Okay? But again, we go down to the exception instead of the general rule. Now, Article 1386, rescission referred to in numbers 1 and 2 of Article 1381 shall not take place with respect to contracts approved by courts. Okay? Even if the guardian suffered damages, okay, or lesion up to 1/4. Okay? This is the exception to the general rule. The damages is actually ground for rescission, but if the contract was approved by the court, then there is no ground to ask for damages, and rescission cannot, as a remedy, be availed. Okay? Okay. Now, 1387 speaks about procedural matter regarding presumptions. Okay? The only way in order for a third person to actually be affected by a contract is one of them, I mean, not the only way, one of them by which a third person be affected by a contract is when, okay, the contract entered into was made in the fraud of creditors. Okay? Being a creditor, third person to a contract, he has a right to the contract, have it rescinded in order to protect his credit. Okay? So there. Now, Article 1388. So who files the rescission in Article 1387? Usually the third person, because that's the individual who suffered damages. Okay? Now, can the buyer also file rescission? Yes, they can, provided they have no knowledge of the same. Okay? Now, so that's Article 1388. Whoever acquires in bad faith things alienating product shall indemnify the later for damages, okay, suffered by them on account of the alienation. whenever due to any cause, it should be impossible for him to return them. Okay, damages, okay, takes effect here instead of restoring the property. So this is again another exception to the general rule. Basically, you do not file rescission then claim damages. Okay, damages usually takes effect when there's a breach of the obligation. Since there is no breach in the obligation here, there's only damage because okay, it was the contract was created in fraud of creditors. Then there is a ground to file rescission. Okay. Now, so that's Article 1388. Okay. 1389. Action to claim rescission must be commenced within 4 years. Otherwise, it extinguishes. Okay. Now, for persons under guardianship or for absentees departure for 4 years shall not begin until the termination of the form's incapacity or until the domicile of the letter is known. Okay? Yes, only persons who are affected by this are the ward people under guardianship. Okay? Or the absentees. Okay, we go to voidable contract. And before that, okay, let's pause for a while, a 1-minute break, and we'll continue with the next video on voidable contracts. But before we leave, okay, or before we start the voidable contract, we will digest the case of Oseta, okay, the one that I just said a while ago. Okay, thank you for listening. Thank you for watching.